This video should find you well if you are interested in understanding the Indian Constitution. Indian Constitution, the biggest written constitution, was taken for a roller coaster ride over this last 7 decades. We came a long way in terms of adjusting to the changing needs. Who in 1950s thought that India will scrap Section 377, legalizing homosexuality or legalizing adultery, that is Section 497. This is exactly what we want you to know. What judgments in our history made this change possible? What's the best case than State of Madras versus Srimati Champakam Dorairajan case in 1951? Let's get into the details of it to see what made it so special. With regard to admission of students to engineering and medical colleges of the state, the province of Madras has issued an order which fixed number of seats for particular communities. That is, out of every 14 seats, 6 were to be allotted to non-Brahmin, 2 to backward Hindus, 2 to Brahmins, 2 to Harijans, 1 to Anglo-Indians and Indian Christians, and 1 to Muslims. In its ruling, the Supreme Court upheld the Madras High Court judgment, which in turn had struck down the government order, or infamously called as Communal GO, passed in 1927 in then Madras Presidency. The GO had provided caste-based reservations in government jobs and college seats. The Supreme Court's verdict held that providing such reservations was in violation of Article 16 Clause 2 and Article 29 Clause 2 of the Indian Constitution. Article 16 Clause 2 says that no citizen can be discriminated as per religion, caste, race, sex, place of birth, etc. for employment in any office under the state. Article 29 Clause 2 says that no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, and language. It was this judgment that necessitated the Constitution First Amendment, which added Clause 4 to Article 15. Clause 4 of Article 15 reads, "Nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and their scheduled tribes." Now that we know the basics of it, let's dig deeper. The chapter of fundamental rights is sacrosanct, and any legislative or executive act or order doesn't have right to override them. The directive principles of state policy cannot override the provisions found in fundamental rights, but have to conform or run as a subsidiary to the chapter of fundamental rights. Now, with these facts, let us look into the issues raised by the parties. The Advocate General appearing for the state argues that the provisions of this article have to be read along with other articles in the Constitution. He urges that Article 46 charges the state with promoting with special care the educational and economic interests of the weaker section of the people, protecting them from social injustice and all forms of exploitation. It is pointed out that although this article finds a place in Part 4 of the Constitution, which lays down certain directive principles of state policy, and though the provisions contained in that part are not enforceable by any code, the principles therein laid down are nevertheless fundamental for the governance of the country. And Article 37 makes it obligatory on the part of the state to apply those principles in making laws, and hence there is no violation of any individual's fundamental rights in this case. Whereas the respondent's issue was the communal GO under the banner of Article 46 is a clear violation of fundamental rights, Article 15 Clause 1 and Article 29 Clause 2 of the Constitution. Caste shouldn't be an hindrance for a meritorious students to get into a institution maintained by a state. But what does the judgment say? This judgment covers both case number 270 of 1951, that is State of Madras versus Srimati Champakam Dorairajan, and case number 271 of 1951, which is State of Madras versus C.R. Srinivasan, which are appeals from the judgment passed by the High Court of Judicature at Madras on 27 July 1950 on two separate appeals under Article 226 of the Constitution complaining of breach of the petitioner's fundamental rights to get admission into education institutions maintained by the state. If a citizen who seeks admission into any such educational institution has not the requisite academic qualification and is denied admission on that ground, he certainly cannot be heard to complain of an infraction of his fundamental right under this article. But on the other hand, if he has the academic qualifications but is refused admission only on the grounds of religion, race, caste, language, or any of them, then there is a clear breach of his fundamental right. Take the case of the petitioner Srinivasan. It is not disputed that he secured a much larger number of marks than the marks secured by many of the non-Brahmin candidates, and yet the non-Brahmin candidates who secured less number of marks will be admitted into 6 out of every 14 seats, but the petitioner Srinivasan will not be admitted into any of them. What is the reason for this denial of admission except that he is a Brahmin and not a non-Brahmin? He may have secured higher marks than the Anglo-Indian and Indian Christians, or for that matter even Muslim candidates. But nevertheless, he cannot get any of the seats reserved for the last mentioned communities for no fault of his except that he is a Brahmin and not a member of the aforesaid communities. Such denial of admission cannot but be regarded as made on ground only of his caste. In Supreme Court's view, the classification made in the communal GO is opposed to the Constitution and constitutes a clear violation of fundamental rights guaranteed to the citizen under Article 29, Clause 2. For the reasons stated above, Supreme Court has opinioned that the communal GO being inconsistent with the provisions of Article 29, Clause 2 in Part 3 of the Constitution is void under Article 13. The result, therefore, is that these appeals stand dismissed with cause. Hence, the argument that as per the provisions of Article 46, the state is entitled to maintain the communal GO, fixing proportionate seats in state colleges for different communities, and as a result, certain individual citizens are unable to get admissions into the education institutions cannot be sustained. The classification in the said communal GO on the basis of religion, race, and caste and is opposed to the Constitution and constitutes a clear violation of fundamental rights guaranteed to the citizen under Article 29, Clause 2. The High Court, by its judgment delivered on 27 July 1950, allowed this application of Srimati Champakam Dorairajan. Let's look into the aftermath effects of this particular case. The case is important for many reasons. Firstly, this led to the first constitutional amendment, no doubt about it. And Supreme Court was clear on importance of fundamental rights over directive principles of state policies, which came into force just an year ago in 1950. This judgment came in when there was no formal parliament set up. It was in 1952 a formal parliament was set up. This case also set a precedent for the cases to follow as far as amending the basic structure of the Constitution and reservations to backward class is concerned. When the judgment was delivered by the Supreme Court, the chairman of the Indian Constitution Drafting Committee, Dr. B.R. Ambedkar, said that the judge did not understand the contents of the constitutional provisions. Massive agitations were held throughout the Madras state under the leadership of Periyar against the verdict of the Supreme Court. Consequently, a new Article 15 Clause 4 was inserted through the first constitutional amendment, which ensured the prevailed reservation rights not only in Madras and other states but also enabled the reservation for implementation throughout the country. Either due to political pressures or social status, later in 2005, through 93rd Amendment, Clause 5 to Article 15 was added, which gives the state the power to make special provisions in the areas of giving admissions into educational institutions, including private educational institutions, irrespective of whether they are aided or unaided by the state. Later in 2019, through 103rd Amendment, Clause 6 to Article 15 was added, which gives the state power to make special provisions for those from the economically weaker sections, also known as EWS, other than those mentioned in clauses 4 and 5 regarding admission to education institutions, including private educational institutions. It gives reservations to the economically backward sections of the society and will be in addition to the existing reservations with a capping restricted at maximum 10%. The reservation made under Article 15 Clause 4 should be reasonable and less than 50%. But Supreme Court is consistently failing to check on this particular issue. But that is a topic for another day. This video is not to support or oppose reservation. This is just an attempt to give you the facts about the events that happened along the process. Thank you.